Principled and effective sentencing is vital to the well-being of any community. The topic is emotionally charged and intellectually complex, and that is the important subject that you have volunteered to explore today.
The principles for sentencing are the same whether it's in the Court of Petty Sessions or the Supreme Court, and you understand, do you not, that the penalties are set by Parliament. The Court doesn't set the penalties, Parliament sets the penalties. Sometimes Parliament will set minimum penalties, every time they'll set a maximum penalty. But in this court, we try crimes which are created by the Criminal Code, and the Criminal Code says that the maximum penalty for any crime except murder is 21 years, and for murder its maximum term is life. And we also have a power to fix a non-parole period. We also have the powers under the Sentencing Act, and so in this court, if someone commits murder, we have what we call a discretion to go right from a bond or dismissing without conviction up to life imprisonment with no parole. So that's a huge range, isn't it? And what we have to do is exercise a sentencing discretion. That's what judges and magistrates do. Within the parameters set by Parliament, we exercise a sentencing discretion. So I just want to run through some principles with you. Why do we do it? What's the object or objects of the exercise? Excellent. What else? Another aim. Rehabilitation. What else?
Deterrence.
Deterrence. General and personal, to stop him or her doing it again. General, in the hope that it'll spread out into the community and others will think, oh, I better not do that or I'll get a long sentence in jail. There's much debate as to whether that really works at all, because I firmly believe that most criminals think they're not going to get caught, and deterrence doesn't operate on their mind too much, I don't think, but I might be wrong, others have a different view. What else?
Prevention.
Call that, as lawyers do to make it difficult for anyone else to do the job, incapacitation. Get them off the streets, lock them up, they won't do it again. And there's a big demand for that, isn't there, in the community? What do you notice about this as opposed to that? What strikes you about it?
One aims to get them out of the community, the other aims to put them back into it.
And so they pull against each other, don't they? Absolutely dead opposing aims. And you would say the same for this, wouldn't you? Yes? And you would say the same for that. If you want to lock them up and keep them off the streets, you're not going to rehabilitate, are you? If you want to bang them away as a general or personal deterrent, it makes the rehabilitation hard. So that's why in every case, from naught to life imprisonment, you've got to exercise a judicial sentencing discretion and strike the right balance. So there are two broad circumstances that you take into account, one being how bad's the crime. So you take into account the circumstances surrounding the crime and the circumstances surrounding the offender, and the effect on the victim. I mean, it's all very well thinking about the offender all the time, but what about the victim? Some lives are shattered, particularly in sexual crimes on young children, incest and things like that. The effect on the victim is so bad, the crime is so appalling, that you've got to show society's condemnation by coming down on punishment.
Every person who appears for the first time on a criminal charge in Tasmania appears before the Magistrates' Court. Hobart, Launceston, Devonport, Burnie, we deal with many hundreds of people throughout the course of the year. Don't forget that although the magistrates and the judges impose the sentences, the Parliament of the state sets out the parameters of the sentencing powers that the magistrates have. And we find the law in relation to sentencing in the Sentencing Act. And you'll see that the purposes are expressed to be promote the protection of the community as a primary consideration in sentencing offenders. And obviously you'd think that's a fair deal. People who are causing havoc in the community and assaulting people, damaging property, this sort of thing, we need to protect the community against that sort of behaviour. Promote consistency in the sentencing of offenders. It is hoped throughout the state that magistrates and judges impose basically the same sort of sentence for basically the same sort of offence. Paragraph E, 1, 2 and 3 are the ones that people will readily recognise. That is, helping prevent crime and promoting respect for the law by allowing courts to impose sentences aimed at deterring offenders. I will sentence you this way so that you will not do that again. And there's an issue, obviously, of general deterrence. In other words, if I give this person 9 months, all his friends will know if they do the same thing, that's what they'll expect. General deterrence. Imposing sentences aimed at the rehabilitation of offenders. Turning them away from crime, particularly young people. Imposing sentences that denounce the conduct of offenders. There is some conduct which is simply so intolerable that a sentence must be imposed based on that particular approach. And one of the purposes of the Sentencing Act was to promote public understanding of sentencing practices and procedures, and of course recognising the interests of victims of offences. What happened to the victim by way of injury, by way of loss, damage, pecuniary loss. Now what can the courts do? Well, Section 7 says record a conviction and order imprisonment. We can order a period of imprisonment suspended, either in part or wholly suspended. In other words, it's put over somebody's head for however long we think is appropriate on the basis that they stay out of trouble. If they don't stay out of trouble, they serve the period of imprisonment, a suspended period of imprisonment. Very strong weapon, I think, in the armoury of sentencing. Community service orders used to be called work orders. Gardening, raking up the leaves, mowing the lawns. So community service orders are a very useful sentencing option in my view. Probation orders. Orders to be of good behaviour, either under the supervision of a probation officer or not. Probation is always a useful purpose because not only do you have the defendant for the 5 minutes or so that it takes you to sentence that person, but you have some restraints on that person's behaviour for however long you want the probation order to run. 1, 2, 3 years, whatever. Fines are obviously a very much used weapon. We can simply record a conviction on someone. Record a conviction, let them go. We can dismiss it without recording a conviction even if we think it is too trivial. Sentencing is not a purely logical exercise, and the troublesome nature of the sentencing discretion arises in large measure from unavoidable difficulty in giving weight to each of the purposes of punishment. Remember back to section 3 about the purposes of punishment. The purposes of criminal punishment are various: protection of society, deterrence of the offender and of others who might be tempted to offend, retribution and reform. The purposes overlap, and none of them can be considered in isolation from the others when determining what is an appropriate sentence in a particular case. They are guideposts to the appropriate sentence, but sometimes they point in different directions. One of the threshold questions, of course, is whether we impose a conviction or whether we don't. And to decide whether you do that, you look at the nature and the circumstances of the offence. What happened? We look at the personal circumstances of any victim, whether the person was defenceless, old, elderly, frail in some way, easy to be preyed upon in the circumstances in which they were preyed. You look at the offender's antecedents, their background, their character. Are they a good person? Have they got any previous convictions? Are they otherwise a relatively stable person? What made them steal the Marsdale? We look to the degree to which the person has shown contrition for the offence. And the way we look at the contrition is to see what action they've taken to make reparation. Have they paid you for your window? Have they apologised? Have they done something which shows that they are taking responsibility for what they did? Whether they've pleaded guilty. If a person pleads guilty, they are entitled to what is called a discount on sentence simply for that. Pleading guilty is a positive factor for the defendant. Sometimes it's the only one. The deterrent effect that the sentence will have on that person. In other words, if you put that person in prison, will that deter them from doing this again? You can usually assess it by way of their reaction to the offence, if they've lost their job or their job is in jeopardy. Their marriage or their relationship is folding up because they're going to go to prison, all these things. Now that sort of effect on them may well stop them from doing it again. The impact that a conviction would have on the offender's economic or social well-being or employment prospects. Convictions for stealing aren't going to do anybody any good when they come to try and get a job, you would think. So the court has to take that into account. We look at the effect under the Commonwealth law of the sentence on the family. Are they going to miss their dad for a while? Well, probably they might. But under state law, you don't take that into account. It's a little unrealistic to have that view, but it seems to me to be a little odd that you can't take into account the weeping family in the back if you send someone through the door there. But anyway, that's the law. If we are shown not to have taken those matters into account, we are liable to be upset on appeal. And of course, as these courts are open, you can come and hear these sentences being given, you can come and hear what we are told about particular people and what we say by way of sentence and why we do what we do. Stand.
Are you Darren Smith? You are charged with motor vehicle stealing, contrary to section 37B1 of the Police Offences Act 1935.
Yes, Mr. Hughes.
Thank you, Your Worship. I appeal for Mr. Smith. Your Worship, Mr. Smith is in a position to enter a plea to the charges upon a complaint.
Yes. Read the charge then. Let's listen to the charge then, Mr. Smith.
You are charged with motor vehicle stealing, contrary to sections 37B1 of the Police Offences Act 1935, in that on 1 July 2002 at Prospect in Tasmania, you're driving a motor vehicle, namely a blue 1980 Holden Commodore sedan registered CO5132, the property of John Black, without the consent of that person or some person in lawful charge of the vehicle, having authority to give that consent. How do you plead?
Guilty.
You are further charged with driving a motor vehicle while exceeding the prescribed alcohol limit, contrary to section 6.1 of the Road Safety Alcohol and Drug Act 1970, in that on July 1, 2002, on Westbury Road, a public street at Prospect in Tasmania, whilst alcohol was present in your blood in a concentration greater than the prescribed concentration of 0.05 of a gram of alcohol in 100 millilitres of blood, namely 0.16 grams of alcohol in 100 millilitres of blood. How do you plead?
Guilty. Right, take a seat in the dock there, Mr. Smith. Yes, Mr. Tors.
Yes, Your Worship. The facts are that at 11:30pm on Monday the 1st of July 2002, police on mobile patrol observed a vehicle travelling on Westbury Road at Launceston. The vehicle was observed to straddle the centre line of the roadway as it negotiated a bend and was subsequently intercepted by police. The driver of the vehicle, Darren Smith, the defendant present in court, was spoken to and he was breath tested. A positive result was obtained in that breath test and the defendant was conveyed to Launceston Police Headquarters for a breath analysis. At Police Headquarters, further inquiries were made in relation to the vehicle the defendant was driving. It was ascertained that that vehicle, a Holden Commodore sedan, had earlier been stolen from Wellington Street. The defendant was breath analysed and a reading of 0.16 was obtained. The defendant was then interviewed in respect to the stolen motor vehicle, where he made full admissions. He stated in that interview that after an argument with his girlfriend at a nightclub, he was walking home to Hadspen. He came across the vehicle in the street and that the vehicle was unlocked at the time. The defendant was arrested for the offences. He was charged and bailed. And there are some prior matters, Your Worship.
They're admitted, Your Worship.
Yes, thank you. Yes, Mr. Hughes.
The defendant is 20 years of age, Your Worship. He is an apprentice motor mechanic. He resides in Hadspen with his partner. It's a stable relationship. They've been together since high school. Your Worship, the defendant's partner is present in the rear of the court. The defendant's partner is in receipt of benefits. Together they are purchasing their own home, so they have a significant financial commitment by way of a fortnightly mortgage repayment. As well as this commitment, they have the usual expenses associated with running a household. The defendant also provides support and assistance for his mother, who has 3 younger children in her care also. So, Your Worship, the defendant does have significant financial obligations in relation to his family and personal circumstances. Those commitments, Your Worship, are about to increase. His partner is 3 months pregnant. That will be their first child. So I seek that you take those financial circumstances into account first of all when considering sentence. Your Worship, the defendant was unemployed since leaving school in Year 10. He obtained his apprenticeship approximately 6 months ago. It's his first position of employment. This is a significant aspect in the defendant's employment history and development. Your Worship, the defendant is highly regarded by his employer and seen as somewhat of a prospect of future employment there, and is also seen as potential for permanency with that employer once he's completed that apprenticeship. Your Worship, I've been instructed, and his employer has advised the defendant that upon the loss of his licence, the defendant will not be able to maintain his position of employment with that employer. I seek that you take that into account. As to the defendant's prior matters, Your Worship will note the defendant has no relevant prior matters under the Road Safety Alcohol or Drugs Act or offences of dishonesty. This particular offence, Your Worship, as indicated by Mr Tors, the defendant had been out with his partner. They had been, he had been consuming alcohol. His partner was the designated driver for the evening. They'd taken the responsible step of organising who was to drive. Unfortunately, an argument ensued between the defendant and his partner drove home without him. The defendant remained at the nightclub for a short time longer, consuming a number of beverages, namely beer. He instructs that the quantity he consumed is consistent with the reading returned. The defendant decided to walk home initially. It's approximately 10 kilometres, the distance between the nightclub that he was at and his home address. He had no income or money for a taxi on that occasion. The defendant noticed the unlocked vehicle, subject of count 1. It's a crime of opportunity in my submission given the circumstances that have surrounded the offence. Your Worship, as far as this particular defendant is concerned, drinking is a rare event for this defendant. The defendant comes from a home that was broken by alcohol abuse and the violence that goes along with it. So it's an unusual circumstance for this defendant to find himself consuming alcohol, let alone consuming alcohol in these circumstances. The defendant realises that today his actions, his consumption of alcohol could cost him quite significantly and those that depend upon him. As indicated by police, the defendant cooperated fully. He made full admissions in his record of interview. The list of prior matters shows that this is otherwise out of character for this particular defendant, and his early plea of guilty before you today is in itself, in my submission, indicative of remorse. Unless I can assist you any further, sir, those are my submissions.
No, thank you, Mr Pearce. Court will adjourn to consider the sentence.
Person, your point is.
I mean, I think that was the original idea of a community service. But it's got all the right
Stand up there, please, Mr Smith. I take into account the fact that you've pleaded guilty. You are a young person without any relevant history. You have significant family responsibilities and you've shown a responsible attitude to those particular pressures in the past. I take the view that this was completely aberrant and out of character behaviour for you. You've faced 2 charges arising out of literally the same act of driving. I'm obliged to impose at least minimum penalties in relation to the charge of exceeding the limit, and I do that on the charge of exceeding the prescribed limit. The reading is high, but it is just into the range of blood alcohol concentrations which attract a minimum penalty of $500 in 12 months. That's a significant penalty for a man of your age. I turn to the motor vehicle stealing charge. You have great future as a motor mechanic. That future will not be enhanced by convictions for motor vehicle stealing. I take into account on this particular charge that the vehicle was undamaged. The vehicle, I assume, has been returned to the owner undamaged. Motor vehicle stealing is a very prevalent offence. It goes on a lot, and there would be members of the community that would, I think, argue quite strongly for a separate and distinct penalty for this particular offence. Taking into account your age, your history, your lack of prior convictions, I'm going to adjourn that particular count without conviction for 12 months on condition that you enter into an undertaking to be of good behaviour and commit no similar offence during that time. And you will appear before the court if you're called upon during that time. I've taken that view because I think that your future as a motor mechanic would not be enhanced by a conviction for motor vehicle stealing. And I think in relation to your situation, the fact that your employer was prepared to speak so highly of you was a significant factor. All right. Stand down. I took a particular view on this particular charge because I thought that the penalty of $500 fine and 12 months disqualification of itself was a significant penalty. And I thought that arising out of the same act, two offences didn't justify additional penalty. You can take the opposite view. You can say that they are completely distinct offences and that they require a separate penalty. And you can take that view both from the point of view of general deterrence, in other words, people who steal or illegally use motor cars should expect some penalty, or you can take the view that for this young fellow with his future, and on this occasion there are some factors in there like his responsibility in the past and his responsibility to his job now, leaving this aside, that might give you a bit of confidence that perhaps he might do the right thing in the future, if given the chance. Of course, you're assessing his character in the time that you have available to you to do that. And that's a very difficult thing. I don't know whether he'll be back in court in 6 months having done it again. I don't know whether he'll never be back in court. But I think in relation to first offenders, this is the only time they can say that. So it seems to me that if the court is going to look towards their rehabilitation, this is the time to do it.
If the offender comes back before you on the motor vehicle stealing charge on the basis that he hasn't been of good behaviour, what penalties can be imposed on him then?
He could be prosecuted for breaching that undertaking, and that in certain circumstances could allow you to go back to re-sentence him on the motor vehicle stealing. It's a bit like breaching suspended sentences. If you give someone 6 months suspended today for 2 years on condition they're of good behaviour, and in 6 months' time they're convicted of burglary, they serve whatever penalty they receive on that burglary, and then the 6 months that you gave them for the other offence is put in on top of that. So the system should catch up with you if you in fact breach those orders, which are made obviously towards rehabilitation, aren't they? And if you're not showing positive signs of rehabilitation, having been given a chance or two sometimes, well, the court might say, well, you've had your chances.
What kind of special considerations can be used in reducing the minimum penalty?
Special circumstances?
Yeah.
Now, I take the view that exceptional circumstances relate, generally speaking, you can't be specific about this, but I think we'll all know it when we see it, sort of medical emergencies, taking someone injured to a hospital when you've been drinking and something like that, or fleeing an attack of some sort. That's previously been held to be special circumstances. But the circumstances must be exceptional. Special is the word.
So I'll just make one further submission to you now that you've made your sentence,
Yeah.
now that you've handed down a sentence. The $500 fine, victims of crime and the court costs, my client seeks to pay that by rates of instalments of $20 per fortnight.
That's fine.
In his personal circumstances.
That's fine, and that will be allowed. First payment within 28 days. Now, he can't pay that fine. He loses his job. He's got no means. He is brought back before the court for non-payment. The court can, if he wants to, then convert that fine to community service. You don't do it the other way. You convert an unpaid fine to community service. You can use community service as a separate sentencing option altogether if you want to. And for a first offender motor vehicle stealing, you might well think about it, as some groups did. And I can see a justification for that.
Unlike the Magistrates Court, you cannot appear unless you're wearing road. The origin is simply historical. Some people say it's good because it upholds the dignity of the court, it makes the proceedings special and solemn, and also it provides the judges with some anonymity. And when you speak and send someone to jail for, say, 15 years or 20 years or something, you don't look as though it's you personally doing this, but it's the figure and the officer of the court. In the criminal side, we wear this red robe. Judges wear around their neck a stole, and that symbolises the church and the mercy that the courts should extend in appropriate cases. Round their waist, the judges wear a belt which symbolises the sword and thus the strength of the court. Round their necks, they wear either bands or a bib. Everybody used to wear bands until about 15 years or so ago, and somehow these were introduced because they're a lot easier to wash and iron. And judges also wear a wig. Right.
On the go. Just have to sleep there.
All persons having anything to do with this sittings of the Supreme Court of Tasmania, draw nigh and give your attendance. Please be seated.
The Queen and Sherry Ann Brown. Place Sherry Ann Brown at the bar.
Sherry Ann Brown.
You are Sherry Ann Brown.
Yes, can I see?
Your Honour, my name is Sheriff. I appear on behalf of the Crown.
Yes, thank you, Sheriff.
May it please Your Honour, I appear on behalf of the Crown.
Good, sir. Thank you very much. Is the Crown ready to proceed?
Yes.
Mr. Sheriff?
Yes, we're in a position to have the indictment read, Your Honour.
All right. Put the indictment to the accused.
Please do.
Sherry Ann Brown, you stand charged with one count, that of armed robbery, contrary to section 243 of the Criminal Code, in that you at Kings Meadow on the 10th day of June 2002 stole $600 from Gary Black, and at that time you were armed with an offensive weapon, namely a blood-filled syringe. How say you? Are you guilty or not guilty?
Yes, please. Yes, sit down, thank you. Yes, Ms. Goodfellow.
Thank you, Your Honour. The guilty occurred in the Launceston Magistrates Court on the 2nd of the 12th, 2002. The relevant date of the offence is the 10th of June 2002, and the relevant charge, as we've just heard, is armed robbery, and it's a sole count, Your Honour. I read the facts onto the record.
Thank you.
At about 9 p.m. on Saturday, the 10th of June 2002, a male employee was working at Central News Agency in Launceston. There were no customers in the shop at the time. Another employee was out the back having a coffee break. A female wearing a balaclava, red jumper and blue jeans entered the premises. She held up a blood-filled syringe and demanded money from the till. She said, "If you don't give me the money right now, I'll stick this into you." The male employee responded by saying, "Go away or I will call the police." The female then approached him, waving the syringe in the vicinity of his left arm. Fearing that he would be harmed, the employee emptied the contents of the till into a plastic bag and gave it to the female. She ran out of the store and was seen running down Elizabeth Street. The male employee called the police. The police located a female, fitting the description, in a cafe nearby. She had approximately $600 on her person, which she could not account for. She gave her name as Sherry Ann Brown, and she was interviewed on video at the Launceston Police Station, where she admitted her involvement in the offence. This is a very serious offence, Your Honour. The type of weapon used is significant, is of particular significance. Here we have a blood-filled syringe. Cherie Brown has threatened to stick it into Gary Black, who's the shop assistant, if he didn't comply with her demands to hand over the contents of the till. The weapon and the specific threat frightened Gary Black, and he collapsed shortly after Cherie Brown left with the money. I refer to Mr Black's victim impact statement, and I tendered that document at this time. And note that he was unable to work for weeks, and that he still has fears about being robbed and suffers from nightmares. It is my submission that no weight should be given to Cherie Brown's statement that she did not intend to harm anyone. What is relevant is that she told...
To whom did she say that?
As part of the record of the interview, that's what is relevant is that she told the target, the victim, Mr Gary Black, that she was going to stick it into him. The target is also of relevance, the target of the armed robbery. It would have appeared to Cherie Brown that there was only one shop assistant in the shop, and the time is also relevant, Your Honour. It's 9 p.m. and it's a Saturday night. There is a need for a strong public deterrence element component, particularly in relation to armed robberies, particularly involving small businesses where there is a sole occupant, the sole shop assistant. Mr Black, like so many other parents, was working the extra hours for his family. The particular vulnerability of these types of workers demands a strong element of public deterrence. The vulnerability of the target is also relevant to specific deterrence, in that Cherie Brown has chosen or selected this particular target because he's there alone and because it is late at night.
Yes.
In terms of prevalence, the public perception is that armed robbery, these types of offences, are prevalent within the community. A further aspect of prevalence is the financial burden it imposes, and I note that on the victim impact statement that he's still receiving counselling some 9 months after the event. These types of offences are relatively new in that the community has been living with the reality of HIV for less than 20 years. The other blood-transmitted diseases, such as hepatitis, also pose significant health risks. The purpose of supplying clean syringes to injectors with people who inject within the community is to protect the health of those people who inject. The purpose is not to supply them with a ready-to-use weapon. I note that Cherie Brown actually stated in her record of interview that she thought it would be a good weapon because people are frightened of being infected. It is my submission that Your Honour should reject the need aspect advanced by Cherie Brown as an afterthought. Cherie Brown told police that the money was for drugs, and then she stated, almost as an afterthought, or as an afterthought, that she needed to buy her 6-year-old some shoes. People in the community would be aware that you can buy shoes for a 6-year-old for as cheap as $2 in a second-hand store. It's my submission that Your Honour would reject that aspect of the facts. In terms of premeditation, Your Honour, the syringe was filled with blood at some point before the crime was committed. The syringe was also taken to the shop. In terms of restitution, it is my submission that any benefit given to the accused arising from the restitution should be seen in the context and is actually caught red-handed. In terms of the amount, Your Honour would be aware that the small amount, or relatively small amount of $600 cannot be seen as used as mitigation. And my authority for that is the case of Reeves, and this is mentioned at page 332 of Kate Warner. In terms of range of sentences that may assist Your Honour, Warner notes that for a single count of armed robbery, custodial sentences range from 3 months to 5 years imprisonment. the median in each case was 18 months imprisonment, and that most of those sentences related to a single count. Warner noted that non-custodial sentences were rare for counts of armed robbery, less than 5% for non-custodial. There were, however, in fairness to my friend, Kate Warner also notes that about half of the sentences under 12 months were wholly suspended, and overall about 15% for a single count imprisonment terms were wholly suspended and 40% partially suspended. In terms of prior convictions, Your Honour, I note that Sheree Brown has breached a bond. Sheree Brown was subject to a good behaviour bond for a duration of 2 years. It was imposed for a similar offence, although not quite as serious as the offence today, the offence of stealing, Your Honour, in November 2000. This is an aggravating feature. Sheree Brown has previous convictions for stealing in 1993 and to possess prohibited drug in 1998. And of course there's a stealing offence for which the bond was imposed, Your Honour. In conclusion, this is a serious offence, Your Honour. It was premeditated to an extent. It has had psychological consequences for Mr Black, for the victim, for the target. The prevalence of this type of crime, armed robbery, is a factor to be taken into account in terms of public deterrence, as are the financial consequences and ultimately the community. The accused has a prior record for similar offences and has breached a bond. Those are my submissions, if I can further assist, Your Honour.
Thank you, Ms Goodsall.
Yes.
Please, Mr. Bar, please stand. Sheree Ann Brown, you stand charged with one count of armed robbery contrary to section 243 of the Criminal Code. Have you anything to say why this court should not give you sentence according to law?
Yes, you can sit down because Mr Sheriff will speak for you. Thank you.
Thank you, Your Honour. Your Honour, before I begin, I should indicate that those prior convictions that were referred to are admitted, and I will be addressing you obviously on those during the course of my submission. Your Honour, if I might begin by outlining some of the background details of Ms Brown. Ms Brown stands before you today as the fifth child of a family of 9 siblings. Your Honour, rather unfortunately, her father was in fact an alcoholic, and a father who chose to abandon his family when Ms Brown was only 9 years of age. She has not seen her father since and has not had any further contact with him. Her mother, on the other hand, was similarly neither a typical helpful or supportive mother. Her mother put her into foster care when she was only 10 years old. She had 12 different foster homes and 4 different schools between the age of 10 and 16. And during the course of her schooling years, Your Honour, she was a poor scholar. Your Honour, sadly, and unfortunately this is often the case, she started using drugs and abusing alcohol when she was only 17 years. And as a consequence of not having any family support or proper home to go to, she lived on the streets at that time. Your Honour, she was also sexually abused by a group of youths in a park when she was only 18 years of age, and that of course naturally enough had a very detrimental effect upon her upbringing.
How old is she now?
Your Honour, my client is now 28 years of age. She'll turn 29 in October.
Thank you.
And Your Honour, of course, as is often the case, my client has never been employed and her prospects for employment aren't good. She had had several relationships over a number of years, and her son, who is now 6 years of age, was born whilst at the time she was living with a known criminal who's currently a resident of Her Majesty's prison. At present, she lives with her son in a Housing Commission home in the suburb of Mowbray. Your Honour, if I may take you therefore to the circumstances of the crime that occurred on the night. As Your Honour has heard, and I take no issue with my learned friend's submission as to the facts of this case, this occurred on a Saturday evening at 9 p.m. At the time, my client was in a terrible state, Your Honour. She had and there's no shying away from this, Your Honour. I certainly don't seek to raise this as an excuse, but my client does have serious drug problem.
And that is not a circumstance of mitigation, though, is it, Mr.
No,
Chair?
and I don't put it to you in those terms, Your Honour.
It's an explanation for the commission of a crime, but not an excuse for it.
And on this night, on this Saturday evening, my client was in the need for, as they term, a fix. Naturally enough, this fix, or this need for drug, comes at a great financial cost. And with my client's circumstances, her financial circumstances being as they are, her ability to meet that need and to satisfy her drug habit, unfortunately, sees her on occasions to have to resort to these means. It's not something that, Your Honour, my client does without thinking, but it is something that occurs when she is desperate. And on this occasion, on this particular Saturday night, my client was indeed desperate. Here is a day on which my client has the opportunity to go down one path or return to the community and become a useful and helpful member of that community. Not a crime undertaken with a great deal of sophistication. She saw the opportunity, she saw the shop with one shop attendant, as she assumed, there was only one shop attendant there. She had a syringe, and on this occasion, on the spur of the moment, seeing the opportunity, decided to commit this crime.
Spur of the moment decision was made, she then drew her own blood into the syringe and then committed the crime.
That's correct, Your Honour. Yes. An indication, Your Honour, of how desperate my client was. Your Honour, having then committed the crime, then went to the cafe where the police apprehended her. Your Honour, my client was in a confused state at this point. She realised what she'd done. She went to the cafe, not knowing what to do next, and of course was soon thereafter apprehended. Having been interviewed, she then was interviewed by members of the Launceston CIB in an interview room here in Launceston, which is obviously a very scary and very intimidating environment. And it was then during the course of that interview that she realised, as she explained to the police officers, from the best of her memory, what she had done, and realised the enormity of the circumstances. She then told police and fully cooperated with their questions and cooperated with the investigation of this crime and admitted her involvement. Your Honour, I submit to you that you can use that and take that as being remorseful.
Yep, I'll certainly do that. In any event, I take into account a plea of guilty because it saves the state time and expense of trying her.
Yes, indeed. Now, Your Honour, if I may take Your Honour's attention to the record of prior convictions.
Yes.
Your Honour will note that there are 3 convictions there for crimes of dishonesty. But my client's convictions in the past, Your Honour, have only been to the point of stealing. The first one having occurred in 1989 when my client was 15 years of age. Your Honour will note that my client is the mother of a now 6-year-old boy, and it was for this, one of the benefits, of course, that she indicated to police that she needed this money on that occasion to buy her child some new shoes. And the financial burdens upon her in looking after that 6-year-old boy have changed such that her financial position has deteriorated. Your Honour, my client, I'd submit to you, does deserve another chance. Your Honour, during the course of the record of the interview, my client realised how serious this was. Having realised what she had done, took the opportunity then, and in my submission to Your Honour, took the very first step in making amends. Your Honour has the opportunity to assist this young lady in stopping her from going any further down that path. I've no doubt Your Honour is considering my client a candidate for an immediate custodial sentence, but Your Honour, I'd submit to you that there are circumstances here that require the suspension of at least part of that sentence. Your Honour, that would have the effect, obviously, of deterring my client from continuing down this path in the future. Those are my submissions, John.
Thank you, Mr. Sheriff. I won't call on you in the pie, Ms. Goodsall. I just need to think about just stand up, would you, Ms. Brown, please? I just want to think about the submissions that have just been put to me, so I will adjourn the court for about 3/4 of an hour.
All stand, please. This court now stands adjourned. Resume at...
No, that's right.
Information's not there, is it?
No. And then if there's a term of imprisonment, is it going to be...
Something to make her think and...
It's caused a lot of conversation in our group.
All right, stand up, Sherry Ann Brown. Sherry Ann Brown, you are for sentence upon your own plea to 1 count of armed robbery. Shortly stated, the facts are that at 9 p.m. on Saturday the 10th of June last year, you entered a news agency in Kings Meadows. A male employee was the only occupant of the shop at the time. You were wearing a balaclava. You were carrying a blood-filled syringe and you used it to threaten the shop assistant as you demanded money. At first he refused to do so, but you approached him waving the syringe, and in fear of being stabbed with it, he emptied the contents of the till into a plastic bag and gave it to you. You made good your escape with about $600. You were apprehended a short while after the robbery in a nearby cafe and taken into custody. You told the police that you needed the money to buy drugs and also to buy shoes for your son, who's 6 years old. You have had an appalling upbringing due to no fault of your own. You are now 28 years old and cannot be described any longer as a youthful offender. From about the age of 17, you've been addicted to drugs. And although you may well have needed money for your son's shoes, I'm satisfied that the reason you committed this crime was to get money to buy drugs. That is no circumstance of mitigation. Your criminal conduct had a devastating effect on the young shop assistant who still suffers from nightmares. Although you've not been to prison before, you have 3 prior convictions for stealing and 1 for possession of a prohibited substance. This crime was committed in breach of a condition you be of good behaviour for a period of 2 years. Regrettably, crimes like this are all too prevalent. Often the targets are small businesses like this one. Penalty has to act not only to punish the offender, but also to send a clear message that crimes like this to feed drug habits will be severely dealt with. Your prospects for rehabilitation are not all that good, but all hope should not be abandoned, and I take into account in your favour that you cooperated with the police and entered an early plea of guilty. The orders of the court are a conviction and a sentence of 18 months imprisonment. There will be a further order that the last 6 months of that sentence be suspended upon condition you be of good behaviour for a period of 2 years from this day. Take it down. That's the sort of sentence that I'm certain would have been imposed in this court if that had been an actual case, and those would have been the reasons. You will notice that I said nothing about drug rehabilitation or re-education or any of those things, and the reason for that is this. You can't force people to do things that they don't want to do themselves. There is a mechanism by which the court could say, I'll impose a probation order for 12 months, and it'll be a condition of that probation order that you obey the directions of your probation officer with respect to drug treatment, education and so on. Accordingly, if such a person doesn't comply with the directions of the probation officer, they're brought back to court and the court will deal with them for breach of their probation order. But we take the view that unless she's motivated herself to shed her habit, all the orders of the court will be fruitless. And accordingly, I took the view that the proper sentence was a sentence of imprisonment. All the court could offer her was a period of suspension, so she'd be brought back again if she reoffended.
All stand, please. This honourable court now stands adjourned. God save the Queen.